To our members of the site as well as to our non-members. Now, a very important note, you will notice that you are muted at the moment, but we want you to engage during tonight's session. So please, if you have a question, more than welcome to go and post it in the Q&A box at the bottom that you will see on the screen. So please engage afterwards. After the presentation, we will allow a few minutes to, of course, answer some of the questions. On that note, if you don't have a question or want to direct a request to our office, you are more than welcome to do so. Send us an email. We can also share with you the link to go and watch the recording after today's session. With CPDs, this session is CPD accredited, so please also note that we will upload your CPDs for your, of course, your participation in tonight's session. With that being said, I'm going to hand over to our host of tonight. Of course, you know him. He's like family. Ryan Elenas is the CEO of MyMed Media. Thank you so much, Ryan. I'm going to hand over to you to introduce our speaker of tonight. Thank you. Over to you.
Thank you, Tanya. Good evening to everyone. Thank you for joining us. I'd just like to point out before we start that these sessions, like Tanya said, are being recorded and they're available via our YouTube channel, which is on the screen at the moment, at Docio Health SA. Also at the end of the session, stick around because you're going to be given a link, a QR code, where you can book a session with our speaker this evening or any one of the speakers during the series. This is part of a 10 webinar series that Bovest Wealth Management has kindly sponsored. And I think that speaks a lot to who they are and what they're about. When we were searching for a particular sponsor, we decided to select Bovest, particularly because, number one, they focus on the healthcare sector. They're very successful in the healthcare sector. And I think that, you know, the fact that they want to develop skills and they want to develop the medical sector through things like these webinars speaks a lot to who they are, their values, and what they're trying to do in South Africa. So tonight we have PJ Buerta. He's a chartered accountant and he's one of their senior management at Bovest Wealth Management. So tonight, let's hear from him. Thank you very much, PJ. Over to you.
Thank you, Ryan. It's a pleasure to be here, and welcome to everyone that's on a Thursday evening about estate planning. So I think some people are in desperate need of CPD points, or they are genuinely have a need about estate planning and thinking about the very important topic. So I'm glad you are here with us. It's not always an easy or a fun topic to talk about, but it's definitely one of those more important topics. But where there's a will, there's a way. So I'm just going to give you an intro into Bovest. And myself, I'm a chartered accountant, studied, didn't like to audit that much, so went into more in the financial advice, assisting and definitely assisting with tax planning. And I think that's where estate planning also comes in. And also definitely did my CFP as well, Certified Financial Planning as well. Our offices is, we have an office in Pretoria where I'm sitting. We also have an office in Stellenbosch and George, but we have clients all over the world and definitely all over the country. So the agenda for today is there's a topics of doctor's dilemma, practicalities of will. So we're going to go through all the topics, and in the end, we're going to speak directly about some doctor-specific estate planning that's very important. But first of all, why estate planning? So I think bad estate planning undo a very good financial plans. A lot of people say, I want to save, I want to do this, I want this insurance in place. But when you don't think about when you pass away, a lot of that gets undone. The good intentions you have gets undone. And I think it's even more important today than previously before, because we are on the cusp of the biggest wealth transfer in history. All the baby boomers, like they said, going to transfer that wealth to Gen Zs or millennials, and that's going to happen in the next few years. So over a third of high net worth individuals in South Africa is over the age of 60. And they say normally in the wealth cycle, the first generation earns the money, the second one grows it, and the third one blows it. So hopefully with estate planning, putting the right structures in place, we can avoid that and have a generational wealth that we can leave to children and give the bare minimum to the authorities to tax, not tax avoidance, but tax planning, that more can go to the generations. And if you have the right structure in place, that can happen. So when we talk about the doctor's dilemma, I think we have, Ruvan, my colleague, also spoke about this, is a doctor's dilemma is they get a late start in life because the studies is quite long, especially if you specialize. You delay the wealth creation accumulation side. But luckily, when you are then done with that, you earn a high income. And on the one side, it's very important you've got this high income, and it's very important to protect that. And that's where insurance comes in and want to protect against litigation and all that things. But in the end, what we want to do, and like where we at Bowers Wealth do, is you want to take that high income and make sure it can not just stay income, but generate wealth. And then if you can generate wealth, how can you generate generational wealth? So I think that's doctor's dilemma. A lot of the time it's stuck with income, but how can it goes over to wealth? And I think we're now after estate plan comes after passes away, how do we do that? So I think the most important one is the practicalities of a will. So I think first of all starts with the basic. You have to have a will in place. So I don't know if you don't have a will in place, there is a law that's called interstate succession where there's a lot of rules that can generate and says that part of that goes to your spouse, then goes to the children. So in theory, that's correct. So your assets will be distributed. But in practice, it's a nightmare. We worked with clients that did not have a will in place. And then the whole process already takes long to work through the master's office and to get everything done. But if you don't have a will, that process just gets prolonged even further. And why do you want to have a will is that you can decide, first and foremost, who's the executor, because that's a very big decision that you make. And that executor can appoint an agent, but in the end, the responsibility falls with the executor. We had one client that's a pharmacist, but got a few pharmacies, and I think like you also doctors that maybe got a few doctor practices. We were appointed the executor, and we had to move quite quickly when the client passed away to put those pharmacies on sale that the employers can continue with their work. So if we weren't the executor and someone else in the bank or in a big corporate and would have taken a few months to get the executor's letter, that whole process would have fallen over and there would have been like a few million less in their estate. So to appoint the right executor is very important. You can appoint the spouse, or I will recommend you appoint someone that you know can take part of the process, but definitely get someone then to assist with that will going forward. Because again, in practicality, it does take a long time, and everyone thinks it's quite easy until they have done one will or estate, and they say they never want to do that again. But that's why there's professional companies that can assist that. Again, why you want a will is you can distribute according to your wishes. We're going to get to the practicalities. You can't do everything that you wish for because there is some practicalities that you have to look for. But you can then decide how you want to distribute your assets. So again, that's where the will comes in place. So that's very important. Some practical considerations when writing a will is if you have minor beneficiaries, make sure there's a guardian, a willing guardian in place. And also, is there a testamentary trust in place for them, because they can't inherit before they are 18 years old. And if they do, it will go to the guardian fund again something that you might want to avoid, to have control over it. And if you put it in inter vivos trust, make sure those trust deed is updated, because then it will be distributed according to that. So make sure you, especially if you second marriage, if the will is distributed and the trust deeds is updated. So that's very important. And remember to keep it safe, and it must be in wet ink. So this is the one document. We are totally paperless at our office, but the one document that you can't have paperless, you have to print it out and sign with a wet ink, is your will. So that's very important, and make sure it's kept safe, and maybe have 2 or 3 copies and with the executor of the will as well, and then you can have original one of that as well. So just we're going to talk about marital regime, because it's very important when you are writing a will. So first of all, if you are married in community of property, and that is if you don't have any anti-nuptial contract and nothing. In the olden days, most people got married in community of property. Then when someone dies, it will be a joint estate, because 50% of the assets is shared. All the assets put together, and the one spouse got 50% and the other spouse got 50%. So it's one estate that's distributed. So it's very important when you nominate your beneficiaries. If you are married in community of property, you can't distribute more than 50% of the shares. You can say 100% of my asset or of the house goes to my children, because the spouse owns 50% of the house. And again, be practical. If your spouse, if you die, you say, I want my house to go to my son. Now your wife or the spouse has 50% and your son's got 50%. Again, it's very important to look at the practicalities of that. And that's also important when you look at writing up a will. Is it practical the way you want to do it? Is it practical to say, I want all my 8 kids and 2 is in Australia to share the house? Or is it maybe different ways that we can do that? So that's very important. So if you're in communal property, it will be one estate, and then the executor's fees, capital gains tax, and estate duty will be calculated on half of that. When you are married outside, out of community of property, but with the accrual, it's also very important, and a lot of people forget that one, is that there's an accrual claim against the will. So let's say you both started at 0, and now the one stayed at home and didn't work, the asset stayed 0, and the other one had a lot of success and has got a will of 20 million rand or assets of 20 million. When that one passes away, can't say that 20 million rand I'm going to distribute to my children or someone else. The other spouse got an accrual claim for that 50% of the marriage that they want to have. Again, there's some clauses that you put in the will that inheritance is excluded and stuff like that. But if in a normal circumstances, there's a claim in that. So that's very important when you do your estate planning, is take into account those accrual claim that someone might have against the estate. Again, you can't say everything goes to trust if the spouse got an accrual claim. So that's very important for people that's married outside of community with the accrual. So there's separate estates, not like in community, it's one estate, it's separate estates, but there is an accrual claim. And that can affect liquidity. We're going to talk about liquidity as well. Where did the money come from for these costs and expenses? And we're going to look at costs a bit later. And then the third one is you are married outside of community of property without accrual. On estate planning, that's the easiest way. Each one's got its own assets, but there's one caveat. The other spouse might have a maintenance of surviving spouse claim against that, but that's a total different law that looks at that. But there is no accrual claim or one estate. Each estate is for itself. And the one that sets up the will can decide how you want to go to assets. But then you look at your own assets and say, this one I want to give to the spouse, and this one I want to give to children or a trust. So make sure your will is consistent with your marital regime. First of all, a lot of people know how you are married. So make sure you are in community or with the accrual and what's the starting accrual values. Because when you get to estate planning, when we do calculations for clients, we want to know what's that starting value with the accrual claim. And again, like I said, consider liquidity when there is a accrual claim. With the accrual claim, if you like 90% of the wills that we see, everything goes to my surviving spouse, and after that it goes to the children or trust. That's perfectly fine because then there won't be an accrual claim because the spouse gets everything. But again, just make sure you don't look at that. Then beneficiary nominations. Ruvan in the previous topic did talk about all the different structures. This is quite a busy slide, but there's a income tax implications of all the different products. So that's very important. And why then beneficiary nominations is very important because that precedes the will. So in your will, you can say, oh, I want to let everything go to my spouse. But if you say on life insurance, for example, now I want it to go to the trust, that precedes what you say in the will. So it's very important to make sure your will's updated. And it's also important to make sure your beneficiaries on your life insurance and your investment products is updated. So like I said, there's a few different investment products. So important to note, pension funds, retirement annuities funds, preservation funds. There's a section governed by Section 37. So what that means, there's trustees, there's a board of trustees. That's basically like a trust. So that's why it's protected against creditors, and they can decide how to distribute it to beneficiaries. So for example, you want to say, okay, my retirement annuities, everything must go to my children, but the trustees will ask, is there any dependents? They will fill in a form, ask for a form. Who's your dependents? Maybe you've got a mother that you are looking after and they want to know that. Because all those people come into consideration and they might have a claim against that retirement annuity. So that's important to note. So even if you want to say, okay, everything goes to my new girlfriend, not to my wife, the trustees can override that 100%. So it's very important just to note that you can nominate beneficiaries, but a lot of that can be override, and that's on retirement products. If you convert that retirement product to a living annuity, that's different. Then you can decide. It's governed by the Long-Term Insurance Act, so it's like life insurance. You can decide, okay, I want everything to go to my girlfriend, and that actually precedes then a claim, and the trustees can't override it because there's no trustees with a living annuity. So that's important to consider. And then there's endowments, 5-year products, sinking funds, a lot of life policies, products. There you can also nominate beneficiaries. Why that's important is you don't have to wait for the estate to wind down, which we know can take a year or 2 years, depending on the complexities of the estate. So within a few weeks, those people that can have the money, the beneficiaries can get that money and don't have to wait for the estate. While the rest, like a unit trust, direct unit trust, flexible investments, money in the bank, direct shares, that all forms part of the estate. And that goes into your estate, and then it says, okay, what's the estate say? How does this got to be distributed? There will be executors' fees on the money because it goes through the estate. The executor manages it. And then after, like I said, with the master's officers get a liquidation distribution account, then it will be distributed to the beneficiaries. Again, but it can be time consuming and there's a bit more extra fees because there is executors' fees. Endowments and the products, like I said, share portfolios, money in the bank, will also have estate duty, while living annuities and retirement products don't have estate duties because they have taxes on the other side. And I'm going to get more to that. So that's very important when structuring your investment products and how your total portfolio looks, is how do I structure it to save on executives' fees and to make it practical for the ones left behind. And then we get to the section 10C. There's a lot of people that did write about this if you read MoneyWeb, and a lot of people come and they said they heard about this over contributions to retirement annuity. They call that section 10C. So I'm going to touch on it. It can be quite difficult, but I think it's important to know about it when we get to estate planning. So normally people contribute to retirement annuities. You can contribute up to 27.5% of your taxable income. So that's quite a lot. It's not only your salary that you earn. You can also on your interest that you earn on other taxable income, like rental properties, 27.5% of that, capped to 350,000 Rand a year. So we have a lot of clients now, especially this time of year, they will say, okay, I want to max that out because I want to get the biggest tax benefit, because I know for every 1 Rand I contribute, I get 45 cents back. So for every 100,000 Rand I contribute, I get 45,000 Rand tax credit. And for most, especially salaried earners or people like doctors with high incomes, that's a big tax benefit you can have. And for some like salaried earners, that's the only tax benefit they can have over a small medical tax benefit they can have. So a lot of people do, they max it out. But now the last few years, people said, okay, but why stop at the 350,000? You can actually contribute a lot more to that. You can contribute 5 million Rand. I'm going to go quickly through example. And a lot of us about why would you do that? Because you only get the 350,000 Rand a year tax back. That's true, but it never gets lost, that contributions you make. Each year it can roll over. So let's say you contribute now a big amount. In the next year, you don't contribute anything. They will say, okay, so I said, okay, but you did make an over contribution. It rolls over to this year, the next year, and then you can use that 350,000 Rand again and again until retirement. Now you say, oh, I didn't use 3 million of that tax benefit. But then when you would start withdrawing an income from that living annuity, you also get that benefit. And like I said, mentioned previously, on living annuities, retirement annuities, there is not, when people take it as an annuity income, there's no estate duty. So there's where a lot of people saw, again, it's tax planning. They say, okay, why? Because in normal investment in an endowment, there will be a 20% or up to 25% estate duty when we can leave it out. And there's also no tax on the growth. So I'm going to quickly go through an example on that. But this is very client specific, and it's not for everyone, but it can definitely work for some people, especially high net worth, or people close to retirement that wants to withdraw in the next few years income. So just for example, this is a client situation, or use 91 use this example. So there's on a pension fund, 12 million Rand, that pension fund retirement annuity again is the same now in the law. The biggest benefit of money in a pension fund, there's no capital gains on the growth, there's no dividends tax, there's no interest. A lot of people miss that as well. Over and above the contributions you make, there's a lot of benefits in that. But when you draw income, that's when you will pay tax. So, but a lot of people say, oh, but then you pay tax on high income. But if you are retired and don't earn max income out of your practice anymore, you won't be on a 45% income. You can manage that with other withdrawals, and you can be on a lower income tax. And with this 45%, like we said, if over contribution, the tax can even be less. Like I said, just important to note, again, money in a pension fund, maybe you want to take it to living annuity, then it's in your hands, the beneficiaries you can nominate. So I'm just going to take an example. If you can going to take this over contribution of 3 million rand, like I said, we take money out of the bank or a flexible investment, and you over contribute 3 million into that, then you can see, okay, now I start taking this as an income. I made an over contribution of 3 million rand, and each year I'm taking a gross income of 600,000 rand. And you see 1, 2, 3, 4, 5 years, I use it, and basically I get that tax free out. They SARS give you that money in the end of when you do your tax return. They say, okay, there's over contribution, so this is tax free. So you take that first amount that you contribute over contribution, 3 million, you get tax free. Hopefully that amount has now grown to 4 or 5 million rand or over, and then you will be again taxed on a normal income like you take a living annuity. So if you, the point that I want to make, if you are close to retirement and you did not make a big contribution to retirement funds and you still want to use that tax benefit, there is still time left, or you can, even if you retire, like I said, make a lump sum with that. And we see it a lot of business owners as well, or someone that might have their own business, medical practice. They didn't save a lot for a pension fund, but now they sold their biggest asset and now they have a lump sum money. And tax is a big problem when you have now 20, 30 million rand to invest. How do I invest it tax efficiently? And this might be one way to do that. And again, you can nominate beneficiaries. You can nominate even a trust with a living annuity. Especially if maybe you don't, or you have children that can't look after themselves, that's a way to look at it. Or if you have a spouse that you say maybe they can't look after the money, and there's a big amount, can nominate that as well. So you can reduce income tax, and again, the big upsides, you can reduce estate duty and executors fees in that. Okay, so then with like I said, the difference between a taxidermist and a tax collector is they say the taxidermist only takes your skin and the tax collector takes the rest. So unfortunately, even if you die, can be very expensive. And a lot of people say, oh, our estate duty is 20% over 30 million assets, it's 25%. But what a lot of people forget is, okay, there's capital gains tax as well. So let's say, for example, you had bought a home or your shares in your business you bought for 0 rand, and now it's over 20 million rand, and you put it in your estate. Now there's also over and above the 20 or 25% you pay. You also pay capital gains on that, a big amount of almost, and then it's almost 18% that you can pay over and above. So there you can see, and then the executor's fee is 3.5% plus VAT, so it's another 4%. So even just worst case scenario, there can be 45% even after tax, the income that you had, the tax money that you have to pay for that. So it's very important to know about the costs that's involved in that. So you want to give the house, you say, oh, I want to give the house, everything to my children or the vacation home or to a trust, but it's important. We know that beach house, especially in the Western Cape, got very expensive. And now we have to distribute those assets. I want to put it into trust, great, but who's going to pay all that costs going in the estate? And that's where another thing is important to know about the cost is what's the liquidity requirements. So now we know we need 5 million rand, but the biggest asset is the holiday home. And now we need 5 million rand for that. So where are we going to get the money? So make sure there is money available in the estate. Otherwise, the beneficiaries will say, okay, we will pay the money to keep this house, or you have to liquidate the house. And sometimes when it gets squeezed that you don't want, put the property on an auction and you know you're not going to get the best price. So that's where life insurance comes in, where a lot of people say, do the calculation, what's the cost going to be, make sure that pays into the estate and make sure. So again, now you have life insurance, but again, look at the beneficiaries. Where does the money go? Now you say everything goes to the trust or everything goes to the beneficiaries. But the idea was for that to pay all this costs. So make sure your beneficiary domination is correct, that everything goes, or the part that you want to pay for all these fees is nominated and goes to your estate. So you can nominate the estate as well. So that's a very important thing to remember, the liquidity. Yeah, so, and a lot of people say, so what can I do to minimize the cost beforehand? So that's where a lot of people say, give with a warm hand while you're still alive. A lot of people make use of the 100,000 Rand donations that they can make without paying donations tax. And again, in you and your spouse, it's 200,000 Rand a year that you can make. A lot of people make it to their trust, or they can make it to their children, maybe open for the children or grandchildren a tax-free savings account, something like that, to make their estate smaller and smaller. Because if you think 200,000 doesn't sound a lot, but again, at 20%, that's 40,000 Rand a year you can save for the beneficiaries. Yeah, unfortunately, it's not for you that you do the tax saving, but it is for the beneficiaries that you can do. And like I said, it's very important to look at liquidity, not only in the estate, but we find it a lot with spouses. Normally, if one is the breadwinner, they say they have all the investment. What happens if this one falls away and the other one, all the assets in the bank is now frozen? How does the other person live? And that's where, again, beneficiary nominations is very important. Or make sure the spouse does have money in its own account. There is money available for the funeral. So it's, again, looking at those different things, thinking about, and that's where estate planning comes in, is thinking about how's the money going to flow, because it's already, when losing a loved one, a traumatizing experience. You just want to make sure the money flows freely and you get what you can make wishes and make sure that it gets implemented like you wished for. We also get the question a lot, are trusts still relevant? And like in all good financial questions, the answer is it depends. At the time, there was a lot of guys that they sold trusts, like, and they sold the structure, and some people had like 3 different trusts and everyone had a trust. So I think that the pendulum swung that way. It was maybe too much trust and it was not necessary. And SARS did come with a lot more regulation. I'm going to touch on Section 17 on interest on loans. But now it swung totally to the other way. And a lot of people say, I don't want trust. I don't want anything to do with that. And like I said, again, it depends, because there can be big advantages. And a trust is anyway a legal entity that you can structure something that can live generation of generations. A PTY or a company can't do that. A lot of people put the trust as a holder and then they put a company below that, because you can't continue with that company, because the company got to have shareholders. So it's got to be a trust that's a shareholder, or it's got to be a natural person. So trust definitely still has its place. Like I said, for a vacation home, beach house, or a farm, definitely is a good example, is that it can go as a generation through generation through that. And there's still tax planning advantages it can have, but it's not, if you only do it for you want to tax, don't want to pay any tax, it might not be the best way to do that. Like I said, a few years ago, I think it's 2017, they came out with Section 17. That means there's no more interest-free loans, because what a lot of people did, they say, I'm buying that beach house for 3 million Rand, and then I just have a loan because the trust don't have any money. loan. That loan stays 3 million until death for 20 years later, and the beach house is now 20 million rand. And Saul said, okay, but I'm losing out on that estate duty. So then they brought in the loan. So that's a big nightmare just to put money for the first time or trust in the first time. Again, if you put in a company with a 0 rand a share, it's quite easy to do that. But again, to put big properties in that is very difficult. So, but again, to protect the assets for generation to generation, there's no better way to do that. And the most cost-effective way to get things into a trust is basically at death, because then you nominate, instead of nominating, always if you nominate something to your spouse, there's a section 4Q, it's tax-free. It's not basically tax-free, it's not a tax saving, it's a tax delaying, because you say, when I give everything to the spouse, I don't pay a tax on now when I die. It rolls over until the second one dies on capital gains and estate duty. So again, for most people, that's fine. They say they don't want to have a big liquidity event. When the first one dies, they will pay the taxes, or the beneficiaries have to pay the taxes when the last one dies, which is fine, but that's why you do estate planning and talk about it. So it's very important then just to know it's a tax delaying. But then to say, even on first one's death, but that's where the planning comes in, take this assets, order life insurance, and make the beneficiary the trust. Because you're in any case going to pay, if you go to children or a trust, you are going to pay the 20%. You are going to pay this capital gains in any case. So especially if it's a lot of assets, it makes sense then to put it into a trust, because you already pay the taxes. And for the next generation, you don't save anything, or they don't save on the first time. But after that, the next generation gets a tax saving, because everything now is in the trust. So I'm going to talk about offshore now, but now with local trusts, and they changed it in the last 2 years. Now a local trust can even distribute not only to natural beneficiaries, South African beneficiaries, they can also distribute to an offshore trust. Again, got to get Reserve Bank approval, but that's a big thing now. If you build a big asset in a local trust and you say, okay, I've got 50 million rand here, and people immigrate, you say, okay, but now I take that 50 million rand and convert it to dollars and can put it in a Mauritius or Guernsey or wherever trust. So again, there's a lot of more planning options than there were a few years ago, and these things change all the time. So next question, what we get a lot is, do I need an offshore will? Ruan also talked about the world's is such a big place, but it's actually getting a lot smaller. I think we all know someone of close family, children, siblings, someone that's living offshore. So the world is getting definitely smaller, and investments, definitely a lot more offshore investments. So normally, it's easy to say, it's a lot about, if you need an offshore will, it's a lot about the jurisdiction. So if you have property or companies overseas, you definitely need to have a tax opinion on that, where that is. Like property in Germany, definitely, I think you will have to have a will in place to what happens to that property, because their laws are different than what we are here. That is here. So that's very important to look at those jurisdictions. But for most of if you have most other cases, if it's only investments and stuff, your South African will be sufficient for distribution. But first of all, then you can also look at products after that. And a lot of people say, okay, just watch out now. Most of our clients are South African citizens. They plan to live in South Africa, but they take money directly offshore. That's perfectly fine. Like I said, the world's a big place. A lot of things to invest in. There's tax benefit because you can get taxed only on the dollar, so you don't get taxed on rand depreciation. It's an awesome vehicle to have money overseas. But then a lot of people say, okay, they put money directly into shares. And then they said, okay, but what about CITES tax? And CITES tax is a tax if you own indirect shares overseas, especially in the US, because most of the shares listed in the big companies is listed in the US. If you are over $60,000, that's not a big amount directly overseas, there can be up to 40% CITES tax. Something that people didn't consider. Then people say, oh, but they have never seen that. But again, like I said, the world's getting a smaller and smaller place. And if the tax authorities in the US says they want to have more tax, and what a better way than to tax all the people that own shares directly in our structures. That's the easy way to do it. There is ways to get around that. There's you can have unit trust or specific things, and there's also we talked about endowments that you can own, that you can nominate beneficiaries. So most people now put money directly offshore in a Guernsey-based company, but they put it in a endowment or sinking fund. And just for example, why they do that here, we call it the global life portfolio. This is not one, but like I said, all the other companies, Allen Gray, Momentum Wealth, Sun Glacier, it's got products like this. There's a few benefits. You pay less capital gains tax. Interesting why also people take money offshore. You don't get tax on income. You just get tax on the capital growth. So you only pay capital gains on the growth of the shares. So the only max tax you will pay on the growth of shares overseas is 12%. And you are protected from probate, because probate is you don't have to have a will offshore, and you're protected against CITES. And again, it's so easy. You nominate the beneficiary and it goes directly to your offshore beneficiary. And you can nominate, even, let's say you have 2 children, you nominate children that's of age, you nominate to one that's in South Africa, you get 50% of the investment and say, okay, I want to continue with my investment because I stay in South Africa, while the other one stays offshore, and they say, okay, I want to take the money because I want to buy a property in England. They can do that. So again, it's important to note, where's the children, how does the money flow, what is the best for your family, how to distribute that. So estate planning, like I said, investments is a lot bigger. You need to take estate planning into consideration. Yeah, and I think then just for doctors specific on estate planning, I think the biggest thing is what happens to your room or your practice when you pass away. And I think most people, maybe they just have a will in place and say, oh, everything's going to go to my spouse, my will, and that's all they have in place. Is the spouse, if your spouse is not a doctor, can't own the property or the practice because they are not medical doctors. So it's very important to have a buy and sell agreement in place. What happens to you, to this practice, if something happens specifically to you? So that's normally we say a buy and sell agreement in place. And that, again, like beneficiaries on investments or life insurance, it precedes the will. So it's maybe in practice good to put in your will, this share will be sold to this and this, but normally there's a separate buy and sell agreement where these people will buy your share, or this will go to this group, and my spouse will receive the money, and we know they are taken care of, don't have to worry about that. So make sure that buy and sell agreement or contract is updated. And a lot of time people put in insurance to make sure, because they don't have liquidity, again, that liquidity question, to say, okay, I've got 5 million rand that I want to pay or should pay. It's great, but I don't have the money. I can pay the monthly premium, but that's where life insurance comes in. But you need to have the contract first and foremost, and then insurance just a method. A lot of people sell insurance, but then there's no contract. You need the contract, and then insurance is just a funding mechanism. Yeah, so just to summarize, and then we can go to any questions, is make sure to check that your beneficiaries is up to date, and especially in the will. Make sure the buy and sell agreement is in place. Again, and make sure the value of the buy and sell agreement is correct. So a lot of time is old agreement, and they valued the practice at 2 million, but now it's at 5 million rand. And then calculate your liquidity on your estate. And yeah, like I said, Ryan, you can maybe ask questions, and if you want to make a consultation or have any questions, can go on the QR code.
Thank you, PJ. That was really interesting. As PJ just mentioned, there's a QR code on the screen. If anyone would like to engage with PJ again, yeah, scan the QR code and you can schedule a free consultation with him. Based on everything you said tonight, I think it's probably a good idea. So yeah, I have a couple of questions. We haven't received anything from anyone yet. If anyone would like to post any questions, you can click on the Q&A button and post any questions. But I'm interested to know what makes a will legal, because I remember attending a talk from an advocate, and she mentioned something about if a minor, so a lot of parents will do this, they'll write out the will and they'll have their children sign as witness. And I think that if a minor, I think it's under 14 or 16, I'm not sure, if they sign as witness, it can actually make the will illegal.
Yes, yeah, definitely. So, first of all, no beneficiaries should witness witness a will, because then you can say, and you sometimes get it out. There's this will that we saw that the person signed, and so forth. So yeah, normally we don't sign as executors or beneficiaries. And I think the most important thing is in wet ink. You only need one original will. It's normally you just give one, but like I said, most people do have maybe two separate ones, because maybe there's someone that says, okay, this is the right will, and this one makes it okay, but luckily we have two copies of the will, and if something gets, the one gets lost. So I think the most important one is make sure then that gets signed, and don't let beneficiaries sign that will.
Would that make the will, what's the word I'm looking for? But
invalid.
Invalid, that's the word I'm looking for, thank you. Would that make the will invalid completely?
Yeah, probably will. Again, the master's office will then sit and the master will decide on that. Like I said, I think you want to give as little as possible. You want to give as much guidance as possible. And you don't want the master to decide, okay, no, we're just going to go the interstate route. Like I said, we had negative experiences. It just takes longer, and then it goes to the guidance fund, and then it goes there. So you don't want that whole situation. So just make sure that you do have official will.
Right. Okay. Johannes van Heerden has asked us a question. He had a trust for many years and would like to stop it now and transfer the property into his private name. And how does he go about that? And is it possible?
Yeah, I think it's possible. All the financial institutions now with the grey listing, everyone said, no, it's fine, you can transfer all this stuff and buy the properties here. But now with all this stuff, they will ask, okay, but where's the list, and where they're going to ask a lot more questions. But it's definitely possible, but maybe there will be, you have to backdate a few things that you have to do and get the trust deed correct. So yeah, but it's definitely something that you can do, is to maybe update the trustee, but you can transfer it again to your own name. But like I said, it's possible. It just might be a bit more admin to do so.
When does a trust become more applicable? Like you said, a lot of people were creating trusts in the past thinking that it was all about tax benefits and you could hide everything in, or excuse me, in inverted brackets, you could hide a lot of your assets, and there were all these tax breaks. And we've since found out that that's not the case always. And now people are talking about having estates in Mauritius, trusts in Mauritius, and those are the benefits. Where are we at now?
Yeah, so like I said, that's a difficult question. What we can see, we have a tax freeze. So the 3.5 million has been a long time, 3.5 million. So it's almost getting irrelevant. It's getting so small. So you're going to pay more and more estate duty going forward. So if you do proper estate planning, you might avoid that. Again, some people say, I don't want the hassle. It's my children's worry. I think it depends on a lot of the assets. So sometimes I agree. It's just, if it's just liquid assets, let that pay the estate duty. But like I said, it depends on that. But when it gets like generational wealth, this is a lot of money. Like I said, maybe over 50 million. Then it's like, so
Sure.
you're going to pay that, they're going to pay 20%, 25%. So that's 15, 12 million. And then when they pass away, it's going to be again. So that's why I say that it can be a difficult question, but I think, are you ready for the hassle? Like I said, some people just say they don't want the hassle because there is a bit of a hassle. There is cost involved, but again, the tax saving you can make is a lot more, especially on those big amounts. So I think.
But of course, you need to be realistic that there are costs involved in managing a trust. So
Yeah,
there's
there's
benefits,
cost
of course.
and effort involved. And again, be practical. If all your children are overseas, does it make sense to have a South African trust, or just
Sure.
on day distribute it to them and then they can decide? Like I said, 20 million rand sounds a lot, but converted to dollars, it looks a bit better now, but it's still not a lot of money. But like I said, now you can put it in Mauritius Trust or somewhere else and bit more. And there's control over the beneficiaries can control. If you are, that's where the trust again is very relevant protection. But if you have let's say children and you are afraid they're going to just spend everything when you fall away, you can't. There's no other vehicle. You can't tell them in endowment they must spend this money wisely, and while the trustees that you appoint on the trust, they can decide, okay, we are only going to give this to the education of the grandchildren, or we are only going to give this monthly or yearly to the children. That's the only way, not rule out of the grave, but you can appoint trustees that you trust that will look after the benefit of the beneficiaries. There's no other way. If you say in your will, I give 25% to my son, I think he's going to blow everything on a motorboat, he can. But that's what I said. So that's where a trust, again, so every situation is quite different. So sometimes people use a trust in the will. It's not a lot of assets, but they know the assets are going to be used what they
right
think it's going to do.
How does tribal marriage and the tribal aspect in South Africa, how does that come into estate planning?
Yeah, it gets a lot more confusing. Like I said, with different like I said, marriages with that. So I'm not the expert on that. I'm also not the expert on the estate. I know about the estate planning, but on the marital law, it gets more confusing because I say the three regimes, but those are also seen as a married in community of property, but it's different ways. But yeah, it makes the estate planning just a lot more difficult.
Okay. Yeah, look, I think that you've covered everything that we could possibly need in one webinar. I think that the one thing that we need to take away is the fact that this is very, very specific to each individual each individual family and their own each individual case. I think it's time for me to have a glass of wine. I'll probably be able to speak clearer then. So yeah, I'd say reach out to PJ if you have any questions, and have a chat to him and his team.
Thanks, Ryan.
Thank you very much, PJ. Have a good evening. This recording will be up by next week on our YouTube channel and also on the same webinars site where you registered for this webinar. Thank you everyone for attending. Have a good evening. Bye-bye.